Good evening and welcome once again to another program of Issues in the News, where we discuss the important events that have arisen over the past week or so. And as is the norm, we always have a packed agenda of issues to discuss. I want to begin by welcoming all of our viewers joining us on television from region number 5, West Coast Berbice. Welcome to another program of Issues in the News. To our viewers again on television joining us from region number 6, along the Quarantine Coast, along the Berbice River, and as far as Oriala and Siparuta of the Quarantine River. Welcome to another program of Issues in the News. And I want to also welcome our viewers and listeners who are joining us on Freedom Radio from Rob Street, Georgetown. Welcome to another program of Issues in the News. And last but not least, to the tens of thousands of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, Australia, and even beyond. Welcome to another program of Issues in the News. Share this program, whether you're using a phone, whether you're watching me on the computer, whether you're watching me on your iPad or on your tablet. Share this program widely so that all the persons on your page and on your account can join us in tonight's discussion. The widest audience possible is always better. So I want to recognize a few of you: Jack Deo, I see Kayum Yasin, Anil Jairam, Ramona Bir Karim, Pam Singh, Bansi Prasad, Leslie Mongal, and these are persons who have been watching me every Tuesday for years, as far as I can remember. Thank you very much for your continued patronage on this program. You are the reason why this program has become so popular and so viewed. I want to encourage you to use the comments section to ask me questions, to voice your views, and I will try as best as I can to address them. If I am unable to do so on this program, as I said to you, I would look at them as soon as I get the opportunity to do so, and in the earliest next program, I will attempt to address them. So do not believe that I don't read your comments and I don't read your questions. And it is important also that we continue this discourse, because when you put ideas out there, you generate discussions, and that is what this program is about. It's about generation of ideas. It's about learning. It's about political education. So I want to always encourage a healthy exchange of thoughts, a healthy exchange of ideas, and a healthy discussion among the viewers. So I want to begin by reminding you that on the 7th of February, that is last Friday, the Chief Justice, the Honorable Justice Roxanne George, delivered a landmark ruling in the Mocha Arcadia squatters case. And that case has far-reaching implications and ramifications for Guyana, where squatting is a serious issue. It also has far-reaching political ramifications. It underscores the importance of persons observing the laws. It underscores the importance of persons not being misled by politicians. It underscores significantly that squatters have no legal rights to the land upon which they are squatting. So, as you know, the land is the government's land, is state lands to be more precise, or public lands. It was owned by Gaisuku and transferred by the previous administration to Nisil, and then Nisil under our government retransferred it to the Central Housing and Planning Authority. So it was never the private property of any person. That's the first point I want to make. These squatters, they claim they went on the land in the 80s. They were unable to adduce evidence to substantiate that allegation and every other contention which they advanced in the case. Throughout that period, from the time they claimed that they were there, we were able to produce evidence to the court, not only of the state ownership, meaning Gaisuku ownership, then Nisil's ownership, then Central and Housing and Planning ownership. We were able to show that without any serious challenge. They were unable to show any scintilla of interest, legal interest in the land. Throughout the very period that they were claiming prescriptive title for the land, we were able to show to the court evidence of their acknowledgement of the government's or the state's title in the land. Once you recognize the owner's title by your actions, by your deeds, and by documents, you can then claim prescriptive title. And that's simple law. So throughout, you had evidence which they could not dispute, and even admissions from them in their own evidence that they were engaging the government to regularize the area. If it is your property as you claim, and it is not the government's property or the state's property, why are you petitioning the state to regularize you? The state can only regularize you if it is the state's land. These are commonsensical principles of law, very rudimentary, very elementary. And the lawyers who presented the case for these claimants committed these egregious errors in their own paperwork to the court. Their case also did not take into consideration the law. And the particular law here is the amendment that prohibits persons from acquiring prescriptive titles to government's lands, state lands, or lands owned by any statutory authority, or public corporation. You would know that in 2009, our parliament passed a law that prohibits persons from acquiring prescriptive title to state lands, or public lands, or government lands, or lands owned by a public corporation. Gaisuku is a public corporation. So, legally, by the presence of that amendment, or by virtue of that amendment, they could have never gotten prescriptive title unless they showed that they acquired it even before that law came into force. That was not their case. So in short, they abysmally failed to establish any legal rights, title, or interest in the land. And as a result, the state was completely justified in taking steps to remove them and their buildings and erections from the state's land. That is the law of Guyana, and that is the law of any other country. The lawful owner of a property reserves the legal rights and powers to take such steps that may be necessary, including using reasonable force, to remove and eject from his or her land any squatter. You do not necessarily need an order of court to remove a squatter from your land. You can do so by self-help, and the law confers upon you that legal authority and power, and protects you as well from any actions that may be filed in relation to the steps that you would have taken to remove trespassers from the land. And those principles came out in this case and were all upheld by the Honorable Chief Justice. The written judgment is not yet available, but as soon as it is available, hopefully we will have it widely circulated. And there are many lessons to learn from this judgment. And I want every person occupying government lands, occupying government reserves, occupying state lands or public lands to take note of this decision and its implications. It means this decision, if you are ever in doubt, clarifies for you, any squatter or potential squatter, what your legal status is. You have no right, no interest, or no title to that land. And the state or the owner can use force and remove you and your erections and buildings from that land without any liability whatsoever. And I hope that the public across this country understands that now. If they never understood it, this case is a timely reminder of the legal position. $2 million in costs were awarded against the claimants in this matter. And I want to speak now to the political dimension. Now, I went back to news stories to refresh my memory. Now, let me briefly tell you that these persons were served with notices as far back as 2008. Those notices requested them to remove and indicated to them that this land will be used for the construction of a highway. So they had notice dating back to 2008, 2009. See, in 2001, the engagement resumed. They were served with fresh notices. The ministers, the relevant ministers, and officials from the CHNPA met with them, invited them to remove, informed them again that a public roadway will be constructed, explained to them that they had no rights, titles, or interest in those lands. Sensible ones listened, and the government offered to all of them lands and buildings, houses, and paid them compensation to move. The government paid some $250 million in compensation to squatters. $250 million to squatters to move. Give them title houses, title lands with houses, and move them, help them to move. And on top of that, gave them $250 million in compensation. These 7 decided that they will not move, and they were encouraged to do so by the political opposition. The leader of the opposition and many members of the opposition used this as a platform for politics and cruelly exposed these persons to the perils that they are now experiencing. And up to now, I have not heard any statement from the leader of the opposition or any opposition parliamentarian or politician saying what assistance they will give to those people who are now homeless and I suppose hopeless. They use those people, abuse them, and discard them. And I hope that persons listening to me will internalize what I'm saying and will not become the victim of political pawns and not allow themselves to be used, abused, and manipulated in the manner that the opposition politicians have used, abused, and manipulated this bunch. I have here a Demerara Waves article dated 7th of November 2022, where Mr. Aubrey Norton, leader of the opposition, held a public meeting at Mocha. And he told the people not to remove from the area. Aubrey Norton held a public meeting and told the people not to remove. He encouraged, I'm reading from a Demerara Waves article. Go and check it. Go and read it for yourself. Monday, 7th November 2022. He encouraged the residents in that area of Mocha not to remove from where he described as ancestral lands. The same foolishness that they keep telling people all over this country. And I keep reminding people that our law does not recognize a concept called ancestral lands. And they go around this country fooling people, telling them about ancestral lands. This is exactly what Norton is saying. He encouraged the residents in that area of Mocha not to remove from where he described as ancestral lands, a reference to lands that had been acquired by freed African slaves almost 200 years ago. Quote, this is what he's saying. When it comes to the road passing through an African village, you want 2,500 feet. Tell them that it will not happen. These are our people's ancestral lands, and it must go to the people of Mocha. And when the idiot comes to tell you that you are squatting, tell them you don't squat on your own property, he said. This is the advice. He's telling the people, don't move. And when the idiot comes, the idiot is the government, to advise them to remove and offer them compensation, you tell the idiot that people don't squat on their own lands. The sad thing is that Norton was not in the court to tell the Chief Justice that. He was not there to represent the people, and I will deal with the representation shortly. None of them were there to represent the people. But let me read what he's saying. The PNCR leader told residents that they must decide who should occupy the land. He said government's only role should be to provide electricity, water, drainage and irrigation so that they can facilitate economic activity, including agriculture. So he's telling the people, stay there. The idiot government, when they come, you tell them that it's your land. It's your ancestral land. Well, the Chief Justice has ruled. You see how politicians misrepresent people in this country? If I am to advise the people, properly, they will tell me that I'm racist, that I'm an Indo-Guyanese and I must not advise African Guyanese. Well, they advise their fellow African Guyanese, and look at what it put them into. It has made them homeless. Those who listen to the advice are all happy and they are living comfortably in their properties that the government gave them, and they received $250 million in compensation. Let me go to another one, another article. This one is Thursday, 12th of January, 2023. Demerara Waves article again. Mr. Dennis Shabral, he writes well. Here, Norton announced PNC National Congress reform-led opposition and coalition on Thursday announced that legal action would be taken against the government for crushing the homes of several persons on the East Bank. And you had Walton, Desir and so on speaking at the press conference. When pressed on why legal action was not taken before in an almost 1 year-long land squabble, the PNC leader said his party has been collecting information to prepare for the legal action whilst believing that the government would have acted reasonably. Right? Norton saying that they're preparing a legal team and they will challenge the government. Well, let me tell you who they have in the parliament at least who are lawyers. Roysdale Ford, Kemraj Ramjatan, Geeta Chandan, Walton Desir, Amanza Walton Desir, and there's a fellow by the name of Raj Kumar, I can't remember. They have 5 lawyers in the parliament. None of them appeared for these people. None of them appeared for these people. No known PNC lawyers appeared for these people that Norton promised he will represent and the opposition will represent. A gentleman from New York named Vivian Williams appeared for these people along with a lawyer named Lyndon Amsterdam. Appeared for these people. A lawyer from America and one from Guyana appeared for these people. No MP from the opposition benches, 5 of whom are lawyers, appeared for these people. So even that promise, they never kept. They abandoned these people, using them for political purpose. They held several press conferences, championing this cause, misleading these people. They went to the United Nations to lodge complaints. But in Guyana, apart from making the headlines in the news, and that's what they're good at, bark, bark, no bite. When it comes to actual representation and rendering actual assistance to these people, no one came forward. But you will hear Amanza Desir will champion the cause of African Guyanese in the parliament. But when the time came to really and practically champion the cause of anybody, I have never seen her in a courtroom yet. And she's a lawyer. Then you had International Decade of People of African Descent. They also made a big furore publicly over this. They announced in the same Demerara Waves article, I want you to go and read it. It's Thursday, 12th of January, 2023. The Ipadaji issued a statement as well. They say that they will provide legal assistance to the families whose houses have been abolished. Where is this legal assistance? I don't know any lawyer who came forward on behalf of Ipadaji. They always have they always have problems with financial regularity. You know that. $500 million of public funds were received by them to purportedly advance the cause of Afro-Guyanese. And they can't point to a singular project of worth. Not a singular project of worth to show that they have expended $500 million of taxpayers' money that they received from this government and the previous government. Here again, the organization said that the Moka Arcada families have coalesced and as a group would engage upcoming negotiations with the government represented by a team of experts organized by Ipadaji. That organization is appealing to Guyanese to donate to assist with relief assistance to the affected. Please click here to donate or visit Ipadaji page on Facebook to find Friends of Ipadaji. The Friends of Ipadaji will provide a full accounting for all donations and acknowledgement of receipts of donations for the purpose of tax deductions. We call on Guyanese of good conscience in Guyana and across the diaspora to support them as they still suffer shock, etc. Where is the money that was received? Did the people receive this money? Certainly this money was not used to provide legal representation. Where is this money that was collected on behalf of these people? I am asking the people now to go and ask for this assistance because these were the people. The Ipadaji. I have a long statement here from the WPA. A long statement from the WPA. Look at the size of this statement. But the WPA consists of 5 old men, 5 old age pensioners. So I don't have the time or the energy to look at this. But go back and listen to what the WPA said. Similar verbiage, encouraging the people to squat, telling them that they have legal rights to be there. And when when the people have been dispossessed legally, none of them are around to offer the assistance. They promised the people that they will find lawyers to represent them. No lawyers came forward from them to represent the people. Certainly, the opposition, politicians who are lawyers, did not appear. None of them. And if the people of Guyana are not seeing this duplicity and hypocrisy, well then I don't know what else I can do to help them. I don't know what else I can do. That is why I'm saying that this case has so many ramifications for us to learn from as a country. This is a classic illustration of politicians abusing and using people to advance their narrow political end and then discarding them when they milked enough public juice from the issue, from the story. I have not, and you know, they like to publicize things. If they had even gone back to those people, they would have put photographs on Facebook. They would have made it a public issue. They will listen to me now, and you will see them now going. So by Thursday or Friday, when they have their press conference, you will hear that they have things to say of what they plan to do is another farce. It is just because I am exposing them here now. And specifically, another lesson to be learned from this case, specifically should be learned by Mr. Nigel Hughes, attorney at law. Squatters do not have rights. They cannot sell that which they are squatting on. You hear that, my learned friend? So the man that you buy 75 acres of land from, he could not have sold you. The Chief Justice just ruled that. And as I am on Mr. Hughes, let me remind him or remind you that he has not yet explained how he got from his party in government a $4 million discount per acre for 20 acres of land at Ogle. $80 million, if we are to assume that 30 million is the price that they set, how come he got it at 26 million? Who got the 80 million? Account for the missing 80 million. Explain to the population how you got a discount of 4 million on the Ogle land. On the LBI land, you got 10 acres. Your company got 10 acres at $10 million per acre. That is $20 million below the government standard selling price at the time. That's 200 million. 200 plus 80 is $280 million. You have to say, where is it? Or explain how the government was shortchanged $80 million for the people's land. It is because it was your government that you got a special price, and you are speaking about cronyism and nepotism and duplicity and hypocrisy, and you are speaking about land giveaway. You cannot come out and make these statements and then run and hide. The public is very unforgiving on these matters. So I will leave that issue there. I believe that I have said enough. And I've given you enough information to go back and research what the politicians were saying to these people who are now homeless. All of them who were advising them are comfortably perched in their homes, most of which they gifted themselves during the opposition while they were in government. But the people are now homeless and are left to fend for themselves. So we have, as I said, a packed agenda of issues to discuss. I spent a substantial amount of time on that. And as we are dealing with the opposition and their hypocrisy and their duplicity, I just want to remind you that GCOM has reported that in the last claims and objections period just concluded, they received no opposition, no claims from the opposition. Over 4,000 transactions were done. Over 4,000 transactions was done in this last cycle. Not a single claim, not a single objection from the opposition. Yet all day long they complaining about biometrics and biometrics and biometrics. Why they are not objecting? I am assuming that the system is working to their satisfaction. And the biometrics call, as I have been saying, is a smokescreen to detract and distract from the fact that they realize that they will lose the next election. So they want now to create a basis. If the system is so flawed, and if the system is generating so many impersonators, and if persons are committing fraud with such great frequency, abusing and manipulating the system, well, then you can't find one. We're not asking you for 1,000 transactions, 1,000 objections. We are asking you for one. Prove one. At least make one complaint. Not one complaint, not one claim from the combined opposition that parroting mindlessly a call for biometrics. They would have proven their case substantially if they were able to go to GCOM and say, look, out of 4,000 odd transactions, this is a sample of 500 where persons fraudulently put themselves on the list or attempted to put themselves on the list. They couldn't establish, they couldn't even make one complaint, not one complaint. And in my view, that illustrates and demonstrates beyond doubt the tenuous nature of their claim and the outrageous nature of the allegations that they are making. So, as you know, Calvin Brutus has filed an alarming number, well, not alarming, a large number of cases against the government. Half of which I think he has withdrawn on his own motion. The others have been dismissed with considerable sums of costs awarded against him. As you know as well, A tribunal was established by the Police Service Commission, utilizing the relevant statutory provisions, and that tribunal was empowered by the Police Service Commission to conduct an inquiry into certain disciplinary charges leveled against Mr. Brutus. That tribunal was given a period of time to complete its work and submit a report to the PSC. As you are aware, the work was concluded and the report submitted, and Mr. Brutus was dismissed by the PSC. That is what the law and the Constitution of Guyana provide. Mr. Brutus did not take the opportunity to avail himself of representation or to appear at the tribunal. He refused. From the evidence that I have seen, based upon the report, the multiple attempts had to have been made to even serve Mr. Brutus documents. He was evading service for days. And when the police was attempting to serve him, he kept taking out photographs of the car, trying to serve him the document, and saying that the police was surveilling him. And that was the cat and mouse show on Facebook. The police trying to get to him to serve him, and he's saying that the police surveilling him. Anyhow, he was dismissed. While the tribunal was ongoing, he filed proceedings again. 2 sets of proceedings. And in one of those proceedings, he sought an injunction. I don't know, apparently, the paperwork, his pleadings, I didn't want to use a legal term, but the pleadings are so badly drawn and drafted by those who are representing him that they are hardly readable. They are not written in, they hardly make grammatical sense, more so legal sense. So it is difficult to understand what type of injunction he was seeking. So the case came up Monday for the injunction. He sued myself, the Attorney General, the Commissioner of Police. He sued the tribunal and all the members, and even the lawyer to the tribunal. And as I read and understood it, the injunction that he was seeking was to preserve the status quo of the tribunal, whatever that means. Literally, it means that the tribunal must remain and must continue to do its work. I don't know how that helps them, but that is what they asked the court for. So I suppose the tribunal read the papers and decided to go ahead, because there was no injunction to stop them from hearing. No injunction was granted, there was an application was made, but when you read what was being sought, it was an injunction to preserve the tribunal. So the tribunal preserved itself and concluded its business and handed the report. The case came up for hearing after that, which was Monday. The tribunal did its work since last week. So that was pointed out to the Chief Justice, and that injunction was dismissed. Then, while we are in the court, they filed another injunction that was served on us in the court itself, in which they sought another order. And this was an injunction restraining the Attorney General, the Police Service and the Police Service Commission from informing Brutus that he was dismissed by the Police Service Commission. In all my years of practice of the law, I've never seen a relief, an injunction like that. Imagine you knock off a man and the man's lawyer come to you, goes to the court and say, court, yes, they knock off the man, but stop them from telling the man that he can knock off. If it was not a serious matter, it would have been funny. That is what they asked the judge to do, the Chief Justice of the country. By this time, of course, the letter of dismissal was already posted to Brutus. Because you can't get him by service, personal service. So the people decide that they will go to the post office and register posts. So I had to explain to the Chief Justice, I don't know, the letter is already posted. Let us just even entertain them for a moment. Just, what are they asking the court to do? To stop the mail halfway? The letter may have already left Georgetown post office. I don't know where we can stop it. Which court will stop the letter now from being received by Brutus? So they wanted an order to injunct the PSC from informing Brutus that he was dismissed. That did not make sense, obviously, and the court didn't waste time with it. The court heard our arguments and dismissed it and awarded $300,000 costs, $50,000 against each respondent. Each respondent. So there's another case that was knocked out Monday afternoon. They have, I think, 2 more left in the system. Let us see what fate they would suffer. I am running out of time here now again. Then there's another matter that was filed recently that made the news. You know, these lawyers, Brutus's lawyers and many lawyers of that ilk, when they file proceedings, serving it on the party that they are suing is a secondary issue. Their primary issue is to get it in the public domain. So rather than serve these proceedings on the Attorney General who they are suing, they are sending it to the press first. I read in the press almost every day from these lawyers, in cases involving these groups of lawyers. I read every day in the press that I'm being sued. When I ask in the office, where is this proceedings? We have not gotten it yet. But I read it in Demerara Waves, I read it on Gordon Mosley, I read it on all the other places. And so, serving it, filing these proceedings, in my view, seem to be more for raising the press than the client's interest. So this is another case that made the headlines in the news. And in this case, a gentleman, I don't know who he is, never heard of him, never saw him before. His name is Brian Collison. And he filed a very unique and unprecedented case. He sued the Attorney General, poor me, every day, 3 times a day they're suing me. Sued the Attorney General, Bharat Jagdeo, in his capacity as General Secretary of the People's Progressive Party, and Aubrey Norton as leader of the PNC. And he wants a number of declarations, he asks in the court, to declare that political parties are legal entities, that they have a corporate stature, that they can own properties, that it was a case that was difficult to understand. And they want the government to pass legislation to make what they were asking for, to make it the law of Guyana. Very unique case. This one was dismissed by the Chief Justice on the 10th of February. That's Monday again. And $1 million costs was awarded. $1 million cost was awarded. The case was filed in November last year, so you can go and get it in the public domain. It was reported in the press, the Brian Collison case. So that was dismissed, and the Chief Justice awarded $1 million in costs against the person who brought the case. We appeared, the Attorney General appeared, Anil Nandlall, the Solicitor General, Nigel Hawke, and Shania Prasad, Omar Hoppe, etc. And we ended up appearing for Norton. Well, we didn't appear for Norton, but we benefited from our representation. And that was a good thing, because if Norton legal team had appeared, perhaps we would have lost. Perhaps we would have lost. So it's a good thing they didn't appear, and they benefited from the Attorney General's representation. And Norton now will end up getting, I think, $1 million cost, because I think they have to pay $1 million cost to the different parties. So we, as I said, we are quickly running out of time. Monday, we have a sitting of Parliament, and a number of important bills will be debated, and equally important, a number of important bills will be tabled. These include the Advanced Passenger Information and Passenger Name Record Bill, CARICOM Arrest Warrant Bill, and the Regional Security Systems Bill. These three bills are CARICOM model legislation that will be implemented across the region. In fact, many countries have already enacted the Regional Security Systems Bill. This Guyana just recently joined the Regional Security System, and we have to pass a law to bring this Regional Security System into our law enforcement apparatus. So this is another, these are crime fighting measures in legislative form, and they are intended to bolster our crime fighting capabilities, not only as a member state of CARICOM, but the entire region is expected to benefit from this, because they are regional pieces of legislation. They are in all the regions. Also, a further amendment to the Court of Appeal Act will be tabled. And in that amendment, the complement of judges of that court will be increased from 9 to 11. You will recall that we made an amendment increasing it from 5 to 9. Based upon representations we have received from the judiciary, we are increasing it from 9 to 11. There is a large backlog. First of all, Guyana is a very litigious country. The caseload is extremely heavy at every tier of the system: the magistracy, the High Court, and the Court of Appeal. We have increased the complements of magistrates. We have increased the complements of High Court judges. It used to be 12, it is now 20. We are now increasing the complement of the Court of Appeal to the satisfactory level. There is now an accumulated backlog of appeals waiting to be heard. We have expanded the judiciary, as you know, financed by the central government, has expanded the facilities at the Court of Appeal, and they are now 2 courtrooms in that building. So you can have 2 Court of Appeals sitting at the same time, of 3 judges each. That's 6. Then you can have another Court of Appeal sitting in another part of the country, perhaps Berbice. That would be 3 and 3, 6 and 3, 9. And then you have 2 judges for those who may be on leave. And you also have chamber applications that are heard at the Court of Appeal and other applications. So a complement of 11 was thought to be a satisfactory number, and that bill will be tabled in the National Assembly on Monday coming. The other pieces of legislation that I refer to, the CARICOM pieces of legislation, they are born out of treaties that we have signed, Guyana has signed at the level of CARICOM, and it's now to implement these treaty provisions and to discharge Guyana's obligations under the treaty. And the names suggest what they are. The Advanced Passenger Information and Passenger Name Record Bill is to keep in a central database all passengers traveling through the region and their cargo, so that that information can be shared among CARICOM member states. And the CARICOM arrest warrant bill is a bill that will allow for warrants issued in one country to be enforced seamlessly and without much legal impediment in another CARICOM territory. So they are self-explanatory in short. Of course, when the debate comes, we will be explaining the details of these bills. My operator is signaling to me that I have once again. Oh, last thing, I remember somebody asked me. On Monday, the 17th of February, the election fraud cases will resume, and the trials are to commence de novo on that date. That's the information I have, and I am making it available to you as someone sent me a message on the program to ask me to provide an update. That's the update that I have. Thank you very much. I think that we have had a good program. A lot of information was disseminated, and I want to thank you for being with me over the past hour. Please enjoy the rest of the evening. Take care, stay safe, and we'll meet again next week for another program of Issues in the News. Thank you.